Hey folks, James Abrenio coming to you from Abrenio Law, your Northern Virginia personal injury and criminal defense law firm. So you were involved in a car accident here in Virginia. It's your belief that the other driver was absolutely at fault, but for whatever reason, law enforcement didn't charge them. They didn't charge them with following too closely. They didn't follow them with failure to pay full time and attention. Didn't charge them with failure to obey a highway sign or a light or reckless driving. And you're wondering what the heck happened, and is this going to affect my ability to be compensated in my Virginia car accident case for the medical bills that they made me incur, for the injuries I had to suffer, for the lost wages, and all that? And I'll tell you, in my experience doing both criminal and civil work, whether or not somebody is charged, in my view, is pretty inconsistent. I've had cases that it's clearly the other driver's fault, where they were clearly recklessly driving and no charge happened. I've had other cases where it was purely just an accident. And this is really a purely civil issue. There's no reckless driving involved. Somebody just rear-ended somebody, and things happen, and there's a charge that comes down. And I still can't tell you honestly what the philosophy is, and I think it comes down really to the individual law enforcement officer. I think some are more apt to charge. Some I've heard, if an accident happens, I have to charge. That's not true, but I've heard that before. I've heard other situations where they don't want to charge because they think it's purely a civil thing, even if it's obviously a real issue. Having dealt with a lot of law enforcement on the criminal side, and obviously on the civil side as well, I can tell you, unfortunately, I think individuals involved can also play a role, meaning who the drivers are. We're talking about whether or not somebody is rude, whether or not somebody's young, whether or not somebody's race sometimes can honestly play a role. And, it is what it is. I'm not here to make judgments for purposes of this video. But what I'm saying is there are a lot of factors that don't go into whether or not reckless driving or a traffic citation or criminal offense should be issued that actually is the deciding factor. So let's say you're in a situation where the other driver should have been charged, but they weren't. Are you out of luck? Now, just to be clear, that does not mean that your case is over. It doesn't mean that you're going to lose. If you were driving down the road and you were stopped at a stoplight and the defendant rear-ended you, even though he wasn't charged or she wasn't charged, a lot of times it's going to be pretty difficult for them to escape full liability. Now, that being said, Virginia applies something called contributory negligence, where if you, the injured party, are found to have contributed just 1% at fault for your accident and they're 99%, you lose. So that can be an issue. Now, you may say, James, well, if I'm stopped at a red light and I get rear-ended, how can it be my fault? Well, unfortunately, people lie. I've had situations where it's clearly a situation where somebody's stopped, but the defendant will claim that no, this person was trying to make it through a light and they stopped short, and they're the reason that the accident happened. And so that's contributory negligence can play an issue even if it shouldn't. And it can make it more difficult if there's no charge and there's no establishing independent factor. So let's say an independent witness. If it turns into a he said, she said, those can be very difficult cases. Now, we will obviously investigate everything around it. The mechanics of the accident, the locations of the cars, if you took photographs, statements from witnesses. Obviously, if there's independent witnesses, we're going to track those down. But just because the defendant, the person that caused your accident, was not charged doesn't mean that you lose. It just means it may be harder. Now, that being said, if it is a situation where we get your case and we're evaluating and we don't think we're going to be able to establish that they're purely at fault, we will be honest with you about it. So we're not going to hide the ball on that. I think if you're talking to attorneys and they're hiding that from you just to get you hired or whatever, I think that's a bad scenario for everybody. Now, let's say, let's talk about the flip side. Let's say they are charged. Just because they are charged also doesn't mean that you automatically win. First of all, the fact that they're charged only comes into court if you go to trial in limited instances. That's really where the defendant does something where he or she's essentially made a statement or done an action that is essentially an admission of guilt. So let's say they go to court and they openly plead guilty. that will be a situation where you can use in court. Let's say they prepay their ticket. That's a situation where you can use in court. Now, other scenarios, let's say they just don't show up. You may think, well, that should be, and let's say they don't show up and they're convicted by court in their absence. You may think, well, that should be enough. That's obviously them doing something to show that they know their fault. Well, unfortunately, at least the cases I've seen and as the case law stands, that's actually not admissible. The fact that they don't show up and a court makes a finding that they're guilty is technically hearsay finding that's not admissible in court. Same thing as, let's say they present to court and they present a defense and they say, I'm not guilty, even if they don't testify and a court convicts them, the fact that they pled not guilty, the fact that they're charged won't even come into court. So, what I don't want to be is a situation where you're so focused on whether or not a charge happened that you're either overly confident or you believe your case is over. Now, that being said, whether or not a charge happened or not, there are aspects of law enforcement investigation that can certainly be used in your case. Let's say people call 911. You can use that to get the recorded statements. You can get that use that to try to get phone numbers of possible witnesses. In serious accident cases, law enforcement will take photographs and do video, and there'll be body camera information and other information that you can get from the law enforcement file, assuming the law permits it. And that's another subject for another video about freedom of information versus discovery and all that. But the fact that there is a law enforcement investigation, whether or not there's a charge, may ultimately benefit your case. Obviously, if you're contributory negligent, it may hurt your case too. But the people that I represent are ones that we are in the right. We're telling the truth, and we believe each other. And if the facts all came out, we're confident we're going to win and that you didn't contribute to the accident. So hopefully this answers your question. If you have other questions, feel free to reach out. Phone number is 703-570-4180. You can check us out at www.abreniolaw.com. Wish you well. Thanks. Bye.